A little bit of background. What they call the procedural posture of this case is that we are years away from a trial. I mean, Trump's claiming there was just a trial. It's utterly wrong. Big surprise. It's something they call summary judgment. That's the posture of the case, and that's the vehicle for the judge listening to this. Now, you wouldn't necessarily know that from the mainstream media coverage as well, because they're also saying the whole thing could be resolved right now, and it won't be. It's in a very early stage. And we haven't even gotten into the really laborious and time-consuming civil litigation process known as discovery, which can take years, consume thousands of hours of lawyers. So in the summary judgment posture, what's important for us to keep in mind is what is the legal standard. And the name summary judgment suggests kind of what it is, which is it's a quick judgment based on the summary of the case thus far. What does that mean legally? Here's the legal standard to win. There cannot be any material facts in dispute, and given that there are no material facts in dispute, one side wins just based on the law. Here's a little bit of me explaining this on a recent CNN hit. We'll just let you hear that for one moment.
It's not a trial yet. It's before trial, and something called a motion for summary judgment. So the legal standard for that is actually very tricky. It means that for the judge to rule as a matter of law that somebody's going to win, they got to first find there's no real material facts in dispute. So obviously there's going to be a lot of maneuvering as to say, what is a material fact? Is it in dispute or not?
So you can find that whole discussion on our Under Color of Law YouTube channel, which I hope you also subscribe to, but you can take a look there for the full interview. The CNN graphic there does a good job of summarizing some of Harvard's main legal arguments, but misses a couple as well. If you apply the summary judgment standard, you might be inclined to think, gee, how can there be no facts in dispute? And you'd be right in a sense, because most cases are about facts being in dispute. But that's where the lawyering comes in, the framing of the facts, so to speak. So here, the Trump administration, for example, is screaming that Harvard is anti-Semitic, which of course Harvard denies. But that dispute doesn't mean Harvard can't win on summary judgment, because Harvard's point would be that that fact does not matter right now, whether there is any anti-Semitism or not, because the Trump administration froze funds without ever getting to the point of proving that allegation. That allegation would be discrimination, of course, would be a violation of Title VI of the Civil Rights Act, which is what the Trump administration alleges.